Chapter 3 Electronic Governance. Legal recognition of electronic records. Where any law provides that information or any other matter shall be in writing or the typewritten or printed form, then notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is rendered or made available in an electronic form and accessible so as to be usable for a subsequent reference. Legal recognition of digital signatures. Where any law provides that information or any other matter shall be authenticated by affixing the signature, or any document shall be signed or bear the signature of any person. Hence, notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is authenticated by means of digital signature, affixed in such manner as may be prescribed by the central government. For the purposes of this section, signed with its grammatical variations and cognate expressions shall, with reference to a person, in affixing of his handwritten signature or any mark on any document, and the expression signature shall be construed accordingly. Use of electronic records and digital signature in government and its agencies. Where any law provides for the filing of any form, application or any other document with any office, authority, body or agency owned or controlled by the appropriate government, with any office, authority, body or agency owned or controlled by the appropriate government in a particular manner, the issue of grant of any license, permit, sanction or approval by whatever name called in a particular manner, the receipt or payment of money in a particular manner, then notwithstanding anything contained in any other law for the time being in force, such requirement shall be deemed to have been satisfied if such filing, issue, grant, receipt or payment, as the case may be, is effected by means of such electronic form as may be prescribed by the appropriate government. The appropriate government may, for the purposes of subsection 1, by rules prescribe the manner and format in which such electronic records shall be filed, created or issued, the manner or method of payment of any fee or charges for filing, creation or issue any electronic record under class A. Retention of electronic records. Where any law provides that documents, records or information shall be retained for any specific period, then that requirement shall be deemed to have been satisfied if such documents, records or information are retained in the electronic form, if the information contained therein remains accessible so as to usable for a subsequent reference, the electronic record is retained in the format in which it was originally generated, sent or received, or in a format which can be demonstrated to represent accurately the information originally generated, sent or received. The details which will facilitate the identification of the origin, destination, date and time of dispatch or receipt of such electronic record are available in the electronic record, provided that this clause does not apply to any information which is automatically generated solely for the purpose of enabling an electronic record to be dispatched or received. Nothing in this section shall apply to any law that expressly provides for the retention of documents, records or information in the form of electronic records. Publication of rule, regulation, etc. in electronic gazette. Where any law provides that any rule, regulation, order, bylaw, notification or any other matter shall be published in the official gazette, then such requirement shall be deemed to have been satisfied if such rule, regulation, order, bylaw, notification or any other matter is published in the official gazette or electronic gazette. Provided that where any rule, regulation, order, bylaw, notification or any other matter is published in the official gazette or electronic gazette, the date of publication shall be deemed to be the date of the gazette which was first published in any form. Section 6, 7 and 8 not to confer right to insist document should be accepted electronic form. Nothing contained in sections 6, 7 and 8 shall confer a right upon any person to insist that any ministry or department of the central government or the state government or any authority or body established by or under any law or controlled or funded by the central or state government should accept, issue, create, retain and preserve any document in the form of electronic records or effect any monetary transaction in the electronic form. Power to make rules by central government in respect of digital signature. The central government may, for the purposes of this Act, by rules, prescribe the type of digital signature, the manner and format in which the digital signature shall be affixed, the manner or procedure which facilitates identification of the person affixing the digital signature, control processes and procedures to ensure adequate integrity, security and confidentiality of electronic records or payments, and any other matter which is necessary to give legal effect to digital signatures. Chapter 4 Attribution, Acknowledgement and Dispatch of Electronic Records. Attribution of Electronic Records. An electronic record shall be attributed to the originator if it was sent by the originator himself by a person who had the authority to act on behalf of the originator in respect of their electronic record, or by an information system programmed by or on behalf of the originator to operate automatically. Acknowledgement of receipt, where the originator has not agreed with the addressee that the acknowledgement of receipt of electronic record be given in a particular form or by a particular method. An acknowledgement may be given by any communication by the addressee, automated or otherwise, or any conduct of the addressee sufficient to indicate to the originator that the electronic record has been received, where the originator has stipulated that the electronic record shall be binding only on receipt of the acknowledgement of such electronic record by him. Then, unless acknowledgement has been so received, the electronic record shall be deemed to have been never sent by the originator. Where the originator has not stipulated that the electronic record shall be binding only on receipt of such acknowledgement, and the acknowledgement has not been received by the originator within the time specified or agreed, or if no time has been specified or agreed to within a reasonable time, then the originator may give notice to the addressee stating that no acknowledgement has been received by him and specifying a reasonable time by which the acknowledgement must be received by him, and if no acknowledgement is received within the aforesaid time limit, he may, after giving notice to the addressee, treat the electronic record as though it has never been sent. Time and place of dispatch and receipt of electronic record. Save as otherwise agreed to between the originator and the addressee, the dispatch of an electronic record occurs when it enters a computer resource outside the control of the originator. Save as otherwise agreed between the originator and the addressee, the time of receipt of an electronic record shall be determined as follows, namely, if the addressee has designated a computer resource for the purpose of receiving electronic records, receipt occurs at the time when the electronic record enters the designated computer resource, or if the electronic record is sent to computer resource of the addressee that is not the designated computer resource, receipt occurs at the time when the electronic record is received by the addressee. If the addressee has not designated a computer resource along with specified timings, if any, receipt occurs when the electronic record enters the computer resource of the addressee. Save as otherwise agreed to between the originator and the addressee, an electronic record is deemed to be dispatched at the place where the originator has his place of business and is deemed to be received at the place where the addressee has his place of business. The provisions of subsection 2 shall apply notwithstanding that the place where the computer resource is located may be different from the place where the electronic record is deemed to have been received under subsection 3. For the purposes of this section, if the originator or the addressee has more than one place of business, the principal place of business shall be the place of business. If the originator or the addressee does not have a place of business, his usual place of residence shall be deemed to be the place of business. Usual place of residence in relation to a body corporate means the place where it is registered. Chapter 5. Secure electronic records and secure digital signatures. Secure electronic record. Where any security procedure has been applied to an electronic record at a specific point of time, then such record shall be deemed to be a secure electronic record from such point of time to the time of verification. Secure digital signature. If by application of a security procedure agreed to by the parties concerned, it can be verified that a digital signature at the time it was affixed was unique to the subscriber affixing it, capable of identifying such subscriber, created in a manner or using a means under the exclusive control of the subscriber, and is linked to the electronic record to which it relates in such a manner that if the electronic record was altered, the digital signature would be invalidated, then such digital signature shall be deemed to be a secure digital signature. Security procedure. The central government shall, for the purposes of this Act, prescribe the security procedure having regard to commercial circumstances prevailing at the time when the procedure was used, including the nature of the transaction, the level of sophistication of the parties with reference to their technological capacity, the volume of similar transactions engaged in by their other parties, the availability of alternatives offered to but rejected by any party, the cost of alternative procedures, and the procedures in general used for similar types of transactions or communications.